Ladies and gentlemen, thank you for joining us for this webinar. My name is Kingshuk Banerjee. I'm part of Khaitan and Company's Disputes Practice Group. As you all know, the topic for today's webinar is the recent judgment of the Supreme Court in the case of Cox and Kings, which upholds the applicability of the group of company doctrine in India. In India, the application of the doctrine can be traced back to around 2012, when it was first discussed in the case of chloro control. And since then, over the years, it's been applied in several cases, not without controversy. In 2022, a three-judge bench of the Supreme Court questioned the applicability of this doctrine in India, posed some important questions, and referred the case to a larger bench. These questions were answered by the Constitution bench of our Supreme Court last month. While upholding the doctrine, the court re-emphasized and reinforced the importance of consent in arbitration. In our discussion today, we will focus on the judgment, the legal and practical implications of the judgment. I do want to clarify that we don't propose to go into the history and the evolution of the doctrine, because that can be a topic of a separate webinar altogether. This judgment in itself throws up several questions which we will aim to, at least some of them we will aim to address and answer in the course of the next 45 minutes to an hour. For those who have joined us in the audience, if you have questions in the course of the webinar, please feel free to submit them using the facility in the webinar portal. We will try and take those questions at the end of the panel discussion, time permitting. If we can't, we will try and respond to you separately after the webinar. Turning now to my panelists, I don't think anybody here needs any introduction. All of you who are attending the webinar have already received an email with the background and credentials of our expert panelists. As I said, none of them need any introduction. It suffices only to state that all our panelists are expert arbitration practitioners with in-depth knowledge and experience in the field of arbitration. With the introductions and preliminary comments from my side out of the way, let's get right into the discussion. And Ritin and Sharan, my first question is for you both. We've had the benefit of observing the reactions to this judgment over the past month or so. And by and large, the perception is that this is a pro-arbitration decision. Would you agree? And if so, what are the reasons? Maybe Ritin, you can go first, and Sharan, you can then add to what Ritin has to say.
Thanks, Kingshuk, and I'm looking forward to this discussion. Your question is whether I agree with the perception that this is a pro-arbitration judgment. And obviously, we're going to go through the detail of the judgment. But it's almost interesting that one aspect is that the court has found that chloro control was wrongly decided. And that was heralded as such a pro-arbitration judgment. So it's almost interesting that we're saying a judgment which says that chloro control wasn't correctly decided, or at least the principle was not correctly decided, is also heralded as a pro-arbitration judgment. When we think about whether a judgment is pro-arbitration, I think we have to be careful to say exactly what we mean by that. Has it furthered arbitration practice in a sound and coherent way? And if I frame the question like that, I would have to say it has. I had argued in the court that the group company doctrine had no place in Indian law, but that to the extent non-signatories were to be parties to an arbitration agreement, that would have to be by placing that within the contours of Section 7 of our Act. And I think the court has done that. The court has now found a principled basis on which non-signatories can be bound by an arbitration agreement. And the other reason I think this is a pro-arbitration judgment is because while doing that, the court has given us much clearer guidance as to when and when not you can include non-signatories as parties to an arbitration agreement. So I think it's on those parameters that I think the judgment, in fact, is, in that sense, a pro-arbitration judgment. Really, the issue that the court was dealing with was what arbitration practitioners have always struggled with, which is joinder of additional parties. and you can go two ways on this. Either you can go in a very Sukanya Holdings kind of way to say that the moment there's a party which is a party to the dispute but not a party to the arbitration agreement, then the entire dispute gets out of arbitration and goes into litigation. Or you can try and do what Cox and Kings now does, which is try and bring those parties as parties to the arbitration agreement. So if you see the judgment, at a couple of places at least, I mean, I just marked out paragraph 92, for instance, where they say you must read the agreement with an understanding of the commercial intent of the parties and give it that efficacy. And giving it that efficacy, then they then rope in non-signatories also as parties to the arbitration agreement. Similarly, at paragraph 100, the court's Gary Bourne saying that we're promoting the efficacy of the arbitration agreement. So really, I think it's pro-arbitration because the court had one view, which is a formal, rigid view of the arbitration agreement, which would have then meant multiplicity of proceedings or potentially arbitrations getting knocked off into litigation. But it chose a more commercial reading and intent of the parties to find non-signatories could be parties to the arbitration agreement. So I like that aspect of the judgment. And then the second aspect, which I like even more, is that while doing so, the court has cautioned that merely because something is in the interest of justice, that can't be the sole criteria. Because that's where chloro control had started and maybe over time meandered into or wandered into a bit more deeply. But the court has been very careful throughout the judgment, I think, to caution us against too expansionist an approach. And I just marked out, 4 quick paragraphs. In paragraph 79, they say it is to be used only in exceptional cases. Paragraph 88 was this concept of single economic entity, which they say is not just common shareholding or common directorship. It is something much higher and much different. Paragraph 90, they caution us that intention must be gauged from the words of the contract. And finally, paragraph 122, where they say that mere incidental involvement in performance, negotiation, or termination is not enough. It must be substantial, and the burden must lie on the party which is asserting a non-signatory to be a party to an arbitration agreement. So I think they have taken a commercial approach and an approach that I find has been very balanced, which is why I think it's pro-arbitration, because even though chloro control perhaps added non-signatories, it did it in a way that wasn't anchored in strong foundations. And that's not pro-arbitration. Even though more parties potentially were getting drawn into an arbitration agreement, that's not necessarily a pro-arbitration. And just one final point, Kingshuk, because when this case was being argued, in fact, Justice Narasimha put a question to all of us, that hasn't chloro control worked well? Or give me illustrations where chloro control has not worked well. And I think it's through that experience of the last almost dozen years that the court has been able to craft certain guidelines and guardrails, as Mr. Khambata argued. So all in all, I would say, yes, a pro-arbitration judgment. It doesn't settle once for all which party will be made a party to an arbitration agreement, but I think that has to be, as the court has said, a fact-based analysis in each case. But I think I would certainly say it's a very balanced and a pro-arbitration judgment.
Thank you, Ritin. Sharon, do you want to add to that?
Thank you, Kingshuk. And first, let me say it's a pleasure to be a part of this webinar with so many interesting and really experienced professionals in the field of arbitration. If I can just respond to your question first on what really is pro-arbitration. One way of looking at pro-arbitration is to accept within the jurisprudence of arbitration that a party to an arbitration need not be a signatory. If that is our perception of pro-arbitration, that is something which was accepted by chloro control in 2012. To that extent, does the judgment push the envelope further? Perhaps not. But there is another aspect or another way in which we look at pro-arbitration. And the other way in which we gauge on what is pro-arbitration is the certainty of a regime. I think when we look at it from the point of view of people in the field of business, what they are more interested in is not so much the jurisprudence of Cloro and the jurisprudence of Cox and Kings. Any business person who engages in business transactions wants to do business in a regime which gives him clarity and which gives him certainty on day one. I dare say that a business person will have no hesitation in doing business in a country where the clarity is that if you have not signed an arbitration agreement, you're simply never going to be a party to the arbitration. That gives you certainty, and that certainty engenders business, which may in itself be viewed as pro-arbitration. So one touchstone of pro-arbitration is not so much that are we binding non-signatories. One touchstone of pro-arbitration is clarity and certainty. And that allows people to structure their business affairs without the risk of someone telling them 5 years later on that a director of a subsidiary sat in a room and participated in negotiations extensively, and therefore that constitutes implied consent. So if we look at it from that perspective also, whilst I do not at all disagree with Ritin, I agree with him, I am only giving you another perspective of what is pro-arbitration. If we look at it from that perspective also, does this judgment introduce more clarity into what are the parameters for ascertaining this question? It does. And to that extent, it is a pro-arbitration judgment, not only because it may perhaps extend to non-signatories, but because it brings in clarity and certainty. Again, I also, when I read this judgment, I also felt that whilst it overrules Cloro, it doesn't overrule Cloro for disagreeing with Cloro on the fundamental point. Perhaps it overrules Cloro because it felt that whilst Cloro accepted the non-signatory position, albeit under the through and under doctrine, Cloro put too many restrictions on when that doctrine would apply. And Cloro also departed from the previous standard in Shinetsu, where Shinetsu says that the court has to take a prima facie view. Cloro seemed to have disagreed with that, and therefore made it harder for a court to come to a conclusion that a non-signatory is bound because the Cloro court did not subscribe to the prima facie view. It's for those reasons that this judgment disagrees with Cloro. Perhaps it felt that Cloro did not go far enough, or the Cloro regime was a more stringent regime. But yet, I do think that Cloro is really what set the ball rolling. And what's more important is not just Cloro, that when we look at the experience of what happened in different courts in the country after Cloro, which is in the Supreme Court and in various high courts, was the cumulative effect of all of those judgments to take us to where we are now with Cox and Kings? I think that in a jural sense, in a legal sense, what Cox and Kings does is not really lay down new principles, but it consolidates the experience post-Cloro and says, this is where we are right now. So it's really a marker of where we are right now, rather than making a quantum leap in and of itself. And perhaps the best indication of Cox and Kings being a judgment which really consolidates the position and lays down the marker as opposed to establishing a new position is in the conclusions of Cox and Kings, where the Supreme Court says that we reiterate completely the judgment in ONGC discovery drilling, which was a judgment pre-Cox and Kings. So when it says that a holistic reading of that judgment is what we reiterate over here, it's yet another indication that this judgment is not laying down new principles for the first time, but really consolidating and laying down the marker. That is also pro-arbitration, because now, instead of looking at a number of different decisions which may have facets which are seemingly inconsistent with each other, we really try and find our answers. And I'm not suggesting you will find all answers. We try and find our answers in one judgment, but now one judgment read along with discovery drilling, which is reiterated in this judgment. None of the other judgments which advance the position are overruled. Neither is Amit Lalchand nor Cheran Properties. Nobody says that they're bad law. But perhaps from a practitioner's point of view, going back to those judgments to understand the extent of these principles may not be necessary, except, of course, if your facts are closer to those facts as opposed to being closer to the facts of Cox and Kings. Therefore, I say in this sense, it is a pro-arbitration judgment, more because of the clarity it gives, as opposed to because it lays down a principle for the first time. I'm not sure it lays down something anew for the first time. And one clear example of where it lends that clarity is it now says that the group of companies doctrine has two parts to it. I think paragraph 118 says that the two parts are, first is the relationship between those entities such so as to constitute them as a group. That's the economic test principle, single economic test. But it says that that is never enough. What it says is that then you have to look at the conduct in respect of negotiations, performance, termination, and in overall in the implementation of the agreement. So you need to satisfy those two. Where it's also helpful is that it says that the extension of an arbitration to a non-signatory is not circumscribed by then taking it to the level of an alter ego or piercing the corporate veil. It says that group companies is different from alter ego and piercing the corporate veil. That may have been one of the gray areas in chloro control, where in paragraph 103, it speaks about alter ego piercing the corporate veil as one of the non-consent based theories for extending it to a non-signatory. This judgment says group company stands apart from that. I asked myself a question in my own internal discussions, that would this judgment therefore extend an arbitration agreement not to a group company, but let's say, for example, to a director of a signatory who is an individual? That may not appositely fall within the group company principle, but more to a director. That is more classic.
I think there's some, I don't know if it's just me, but I think Sharan's screen is frozen. And Sharan, while Sharan comes back, let me just move to Steve and Sanjeev. In the meantime, I'll stay with the same topic, Steve and Sanjeev. The judgment, what it does for the first time, at least my understanding is, it consciously and expressly departs from the legal position in the UK and even Singapore, and takes a view that we need to adopt what it describes as a modern approach to arbitration, which is to balance consent. Ritin, you mentioned the commercial approach, and it introduces some degree of balance. The judgment does say that, look, it's important to balance consent and modern commercial realities. Do you expect this approach, Steve, maybe you can go first, do you expect this approach to improve India's attractiveness as a seat of arbitration, or do you think it's going to have a reverse effect? Sharan, you're back, but you want to finish your response? Sorry, we moved on because we weren't sure if you're...
Kinshuk, carry on. I'm sorry, I logged off for some reason. I can come in, I can finish my thoughts somewhere down the line. I'd rather you continue after with your question that you've asked Steve.
Thank you. Thanks, Sharan. Steve, why don't you go ahead?
So Kinshuk, thank you, and thank you for inviting me to be part of this. I think the question, let me take a step back. I don't think chloro control was as damaging to India's reputation as some people might think it is. So I'm not sure that decision really hurt India's standing as a seat of arbitration. I also think, and I think we'll come on to this as we talk, that one of the issues, including the modern approach that the court talks about, that one of the lessons to take from that is that parties have it within their control to regulate risks around who will be found to be subject to an arbitration agreement, and you can contract for that. And I think both decisions, but particularly the focus that Cox and Kings has given to this question, should hopefully encourage lawyers and commercial actors to be thinking, when they're in contracts, particularly with multiple parties, or in a context where there are multiple contracts or groups, to figure out, do we want to be subject to arbitration or not, and to think more about that. So I think that's a net positive. I do think, though, if you ask the question, will this hurt or help, putting aside how much the people who draft contracts are paying attention to decisions like this, I think it can only help, because I do think chloro controls, for people who are paying attention, was a decision that was puzzling. The reliance on the through and under language was not, I think, something that shone a good light on the court's reasoning. So I think moving to a regime that really clarifies, as Sharan said, and creates more certainty, can only help. And I think that's where Cox and Kings is a positive in terms of the view of the Indian mark it as a place for arbitration, because what you have is a decision that does, I think, restrain the excesses of the application of chloral control, gives a more certainty about in what circumstances a non-signatory can be subject to an arbitration agreement. It still will be fact-based, and we'll still have lots of creative arguments that are made about the facts, but it also moves away, I think, from what is most criticized, and we'll come on to this later, but what's most criticized in the courts that have rejected the group of companies doctrine, which is the simple assumption that a single economic entity is enough to create jurisdiction. So I think in that sense, it's only a positive decision, because it's a more thoughtful, and it is a more modern decision, and it is wrestling with something which is, I think, important to users of arbitration, but more generally to people who are involved in multi-contract, multi-company transactions, which is creating a dispute resolution mechanism that's sensible and efficient, while respecting corporate differences and privity of contract. And I think the court has wrestled with that in a way that is impressive and may help, and again, we'll come on to this a little bit later, but may help other courts who are trying to figure out how to deal with that situation, maybe under other labels, maybe not under the group of companies doctrine, but the question of consent. What do you look at to ascertain whether the conduct of the parties show that there really was a sufficient consent to say we should have them all be part of one dispute resolution process? And so I think in that sense, it's a positive decision. And if I'm a corporate lawyer or a commercial person thinking about a deal with Indian parties that may be subject to arbitration in India, more certainty, more clarity, and a decision based on principles that are easier to understand can only be good.
Sanjeev?
Oh, thank you, Kingshuk. Thank you. It's a pleasure to be part of this webinar. And I think I agree with all my esteemed friends that essentially this is something which is going to be beneficial to India and its reputation, etc. And Steve made a point that essentially an arbitration agreement is something which is anchored on the consent of the parties. And I think the Indian court and Indian court in Cox and Kings judgment did indicate that it wants to be in tune with global practices of arbitration, and therefore it did consider the global practices. On one side, it looked at what's the law in UK and Singapore, and on the other side, it looked at how the law has evolved in USA, Australia, France, and Switzerland. But in both cases, I think the arbitration is fundamentally anchored on the principle that a party cannot be made to be submitted to the process of arbitration unless it has consented to the same. And obviously, consent, Cox and Kings says, is the cornerstone of the arbitration. So the real difference between two approaches, England versus, let's say, France, is how that consent is to be inferred. Now, the English and the Singapore law are much more restrictive in their approach in inferring the consent, and they obviously expressly reject the doctrines like group of companies doctrine, though they do definitely extend the principles of defined legal relationships like agency, innovation, assignment, merger, succession, etc. On the other hand, in case we come to the approach which is there by the other side, the approach is quite liberal in France, US kind of law, and they do adopt views like group of companies doctrine. And India, I think when we come to the Cox of Kings judgment, India kind of aligns itself to the more liberal kind of an approach to that consent. And Cox and Kings says that concepts like, let's say, group of companies doctrine, relationship between the parties, commonality of the subject matter, nature of the transaction, whether it is composite or not, involvement of the party in negotiation and execution of the contract, would also be principles which would be looked by the courts while implying consent in a party, and thus whether it can be subjected or not subjected to an arbitration agreement depending upon the factual analysis in such circumstances. Now, and just giving a kind of different perspective, while privity of the contract and intent of the parties to be bound by an arbitral process is the cornerstone of the arbitration process, and which obviously has been given more predominance by UK and Singapore law. I think equally the finality of the arbitration process and avoidance of multiplicity of the proceedings and fragmentation of the disputes is also equally important for an arbitration process. And my view would be that the Indian approach would strike the right kind of a balance between both these aspects, while obviously it's going to ensure a very rigorous analysis of factual circumstances to come to a conclusion as to whether an implied consent can be inferred or not. But it will also ensure that a non-signatory party, though otherwise might be bound in a factual, like let's say metrics, by the terms of the contract, will not be able to circumvent the process of the arbitration by, let's say, filing some kind of a satellite proceeding, and thus leading, thus, in my view, this approach is going to lead to certainty and finality of the arbitration process. And I might say that in view of the model commercial world and the complex transactions which we are seeing, I think that kind of an approach might actually improve India's attractiveness as a seat of arbitration, because obviously we have seen that when commercial persons are executing the contracts, they are not really redrawing the contracts because there's some change which is happening. Obviously, once the contract has been executed, then the parties go on with the execution, and then you would see lawyers are not really involved. It's obviously the commercial teams which are there. And obviously, it might not be possible for every time to them to come and new parties coming in to redraft the agreement, etc. So maybe it's more, as the Supreme Court puts in, more aligned with the commercial realities of the complex commercial arbitrations and transactions which we are entering into. And obviously, the other point which I'll not emphasize, I think Sharon has made that point, and I completely agree with it, is certainty is more important to business than obviously. And I would say 2013 onwards, non-joinder parties who were not signatories, they were added into arbitration in India. And Cloro is not the only judgment. It is followed by Charan Properties, then Amit Lalchand, then Racket, then Canara Bank, finally with Discovery. So I think in Indian commerce world, people are used to obviously the law being of this kind of a nature. And obviously all the transaction documents and the commercial contracts have been drafted keeping this kind of a reality in mind, that maybe in certain circumstances, even if you're a non-signatory, you may be drawn into. The judgment does, I think, make the principles on which a non-party can be made a party to an arbitration much more robust on a detailed kind of fact-based analysis, and not merely dependent upon, let's say, one legal doctrine. It is, I think, the composite universe of the transaction which is required to be looked into. And obviously there is certainty, and the test is more rigorous as compared to other. But I think for all these factors, I would say this judgment would make India a more attractive kind of a destination, rather than to, let's say, pull away arbitration work out of India.
Thank you, Sanjeev and Steve. Niti, just turning to you, and maybe you can give us the institution perspective. Do you also view this as a judgment that's going to attract India as a seat of arbitration?
Thank you, Kingshuk. I should start by saying that it is very heartening to see that you thought that you should involve an institutional perspective in the discussion. Clearly shows that India is not only going, guns with the arbitration law, but the institutional arbitration is picking up as well. So thank you so much for thinking of an institutional perspective. But I must say that what I'm going to say is going to be more of my personal view rather than an MCI view, though I don't think it would be very different. But I should, as a good lawyer, make that disclaimer.
Yeah, we won't hold you to it.
Sorry?
We won't hold MCA to it. Let's clarify that.
Sure, thank you so much for that. But yes, I think it's a very positive development. I don't think anybody can really deny the fact that it's a positive development. We've heard all our four speakers before, give us the reasons why it is positive. And it's always good to have a judicial framework, which supports the development of what's happening internationally in the arbitration world as well. And to see that India is not now lagging behind or catching up, but sometimes taking the lead as well to develop that law and say that we are all ready to have arbitrations seated in India, you will not be surprised with what the law really is. So in that aspect, I think it's a very positive development, and parties would feel more encouraged at least, or at least feel the comfort they can choose India as a seat for arbitration, which of course augurs well for all of us sitting here on this webinar as well. But I think there is a caution which needs to be looked at as well, is that with what chloro control, as Sharon said, is a very restrictive, and now we have kind of liberalized it a bit more. But barring the businesses which are very sophisticated, and while they're entering into contracts and maybe having the best of the legal advice, may keep these things into mind. But can we really say that the Indian parties, and now I'm talking about purely where two Indian parties are involved in a transaction, are we really at that stage in the business where the business understands the effect of this judgment and what it can lead to? Just to give you an example from an institution's perspective, right? We don't have the rules, and I'm going to come on the MCI rules in a later part of it. But as of today, if you see, we do not have rules for joining of non-signatories. And if an institution was to look at if it's a purely Indian parties or it's an Indian seated arbitration, taking from what Cox and Kings says, if an institution was to allow a non-signatory to be joined to an arbitration, will that open up a space for a party to challenge that decision of the institution in the court? Quite. We all know that Indian lawyers are quite famous to go to courts at the drop of a hat, with no offense to anybody, but that's how the system works, right? And then would the businesses feel that something which they weren't aware of or which they were not ready to be, now with a very liberalized approach, are seeing themselves to be binding non-signatories to an arbitration? I think that is where I feel that though it's a positive development, but we need to have some cautious approach. I think a lot of outreach of this sort, which I congratulate Ketan and company to be actually putting together and to be talking about it. A lot of outreach would need to be done, because parties now need to be careful when they are negotiating, when they are probably drafting as well, either to have a language which clearly says what will be the effect and how they want the contract to be governed. So we will really see the effect of this judgment, I think, in the long run, in the next couple of years, to see that how business has adopted it and where we are in terms of, are we increasing the caseload of our courts, of more decisions of being challenged in this sort, is what I would say.
Thank you, Nidhi. I think you made a couple of very valid points, and we'll come back to you on the MCI rules. Sharon, if I can ask you my next question. One thing that the Supreme Court does in this judgment is emphasize the importance of limiting the role of a refereeing court, especially when dealing with this issue of joinder of non-signatories. And to that extent, the court does enhance the power of the tribunal and clarifies that this is something that should be left to the tribunal. But what this judgment doesn't answer, at least I didn't find an answer in the judgment, is whether a party can directly approach a tribunal to implead a third party or a non-signatory. I don't think the judgment answers that. Any thoughts on that, Sharon? And do you think this judgment will have a bearing on impleadment applications directly to a tribunal?
Thanks, Kinshuk. Let me answer first your question very briefly and then try and elaborate. Does the judgment categorically answer the question that you raised, namely whether the tribunal is vested with power to entertain an impleadment application to join a non-signatory? The conclusions of the judgment do not answer that question. However, that said, if you look at Part G of the judgment, and specifically paragraphs 161 to 164, I think that the judgment does more than hint at the answer in those parts of the judgment. And the way that I read the judgment in those paragraphs and the observations made in the judgment, which is by no means referring to counsel's submissions, those are observations made in the judgment itself. The way I read it is that in the context of the joinder of a non-signatory to an arbitration on the basis that the non-signatory is nevertheless a party to the arbitration agreement, though not a signatory. The judgment seems to indicate that the process to be followed is really in two stages and in two parts. And when we read those paragraphs of the judgment, we have to keep in mind the statutory frame of the Arbitration Act itself, because I don't think that we can answer this question only by reading a judgment. We necessarily have to look at the first principles of the Arbitration Act. And when I look at the two in juxtaposition, my conclusion is that in respect of a non-signatory, in the normal run, if you were to invoke arbitration, be it against a signatory or a non-signatory, that is where arbitration commences. And that is what the Arbitration Act says under Section 21, that the arbitration commences with the invocation of arbitration. Now, take, for example, when you invoke arbitration against a signatory. So you don't have to get into any of the consent theories because the party is a signatory. But the signatory is non-responsive to the arbitration invocation, or otherwise feels that there is no dispute to go to arbitration. What is the drill of the Arbitration Act in that conventional situation? The drill of the Arbitration Act is to constitute a tribunal, which is the tribunal that will adjudicate the dispute. You have to go to court under Section 11. That's the drill of the Arbitration Act that we cannot lose sight of, even as against a signatory, without any controversy of implied consent, group companies, etc. If you go to the Section 11 court against a signatory, the only question to be examined is there an arbitration agreement in existence? That law has now been established and refined, and that's the limited role of the Section 11 court. Is there an arbitration agreement in existence? Apply these principles as first principles to an invocation against a non-signatory who the invoking party believes to be nevertheless a veritable party to the arbitration agreement on one of the consent theories. The non-signatory is, common sense and experience tells us, is going to resist the arbitration. How do you then compel that party to arbitration when they are a non-signatory? The process can't be any different than what you would do as against a signatory, which is to go to the Section 11 referral court and tell the referral court that, look, even though this party is a non-signatory, there exists an agreement. The existence of an agreement really is as between two people. It's not like the existence of a physical artifact. It's an agreement between two people. You tell the 11th court that there exists an agreement between me and the non-signatory, notwithstanding the fact that the party is not a signatory. There is various theories like the group companies doctrine, alter ego, agency, to establish that the non-signatory is nevertheless a consenting party. That is where now, when we keep these first principles in mind of what Section 11 is intended for, now please come to 162 to 164 of the judgment, read in light with Section 11. And I think that the answer is that whilst in para 162, the last sentence says that the present position of law is that the referral court only needs to give a prima facie finding on the validity or existence of an arbitration agreement. So it still talks about the referral court. The clearest indication that you are expected to go to a referral court as the first pit stop to make a prima facie determination of this issue as against non-signatories is to be found in paragraph 164. 164, to my mind, read with Section 11 and the drill of the Arbitration Act, answers the question, even though the answer is not to be found in the conclusion. Para 164 is in two parts. It says that the approach to be taken by the referral court when faced with a situation of invocation against a non-signatory is only to form a prima facie view. But that's the view to be formed by the referral court. The second part of para 164, in contrast to the first part, then tells us what the tribunal has to do after a referral is made, that is, after you satisfy the prima facie threshold. And the tribunal's view is not a prima facie view. The tribunal's view, when explaining the role of the tribunal, the judgment does not use the adjective prima facie. It says decision of the tribunal, which means a full-fledged decision of the tribunal, And I can imagine situations where that decision would entail perhaps limited evidence on the aspect of group companies, relationships, and so on and so forth. Therefore, to answer your question, Kinshuk, I don't believe that the judgment lends itself to a view that a party invoking arbitration can directly go to a tribunal, bypass the rigors of 11, bypass the normal role to be played by the 11 court, go to a tribunal and say that you make the first determination of whether a non-signatory is a party to the arbitration agreement. I think that that's really the second determination after the prima facie satisfaction of the 11 court. And that stands to reason because when we look at this by taking a step back, the judgment, whilst of course it extends to non-signatories, must be viewed as a balanced judgment. And the balance in this case is to balance the proactive intent of the party invoking arbitration, who obviously wants to rope in everyone across the board. But that must be balanced with the fundamental principle of consent, that arbitration is a consensual process. And the role of the 11 court is extremely crucial in maintaining that balance and maintaining that parity, as opposed to allowing a tribunal for the first time to make an adjudication of this matter by joining a party or making an impediment application to the tribunal. That, to my mind, and if I may just add a nugget of information here, whilst this judgment adopts ONGC discovery drilling, the peculiarity in the facts of ONGC discovery drilling and why there was no Section 11 involved over there is to be found in the High Court judgments in discovery drilling. There, what had happened is that in arbitration was invoked against the signatory and the non-signatory. The non-signatory, instead of resisting participation in the arbitration, in my opinion, made the fundamental mistake of going and appearing before the arbitrator, even though there was no role played by the 11 court. But once it appeared before the arbitrator, it then took out a 16 application and told the arbitrator, you decide whether I should be here or not. By its own conduct of participating in the arbitration, even to the extent of raising the 16, the non-signatory has given up the point that I just made, that it could never have been taken to arbitration without the first stage of the Section 11 court making the prima facie determination. So to answer your question, whilst there's no clear answer, I personally lean in favor of the view that to rope in or to extend it to a non-signatory, you have to go past the pit stop of the 11 court. That's an important provision and safeguard of the Arbitration Act, which must be maintained.
Thank you, Sharan. I mean, that's a really intricate analysis and a lot of food for thought for all of us.
Can I add one little comment to that?
I was expecting more participation on that question. Yes, please, Ritin.
No, I think one area which has not been fully answered is, and it's exactly flowing from what Sharan also just mentioned. When you have a contract between A and B, and therefore they are parties to the contract, and the arbitration also agreement contemplates that A will nominate an arbitrator, B will nominate an arbitrator, and those two will nominate a third. And then you say, A asserts, for instance, that C is also a party to the arbitration agreement. In that process of formation of the tribunal, C has no rights under the arbitration agreement as drafted, as literally drafted. And so that could be perhaps the odd occasion where it goes directly to a tribunal, because C has no role in the constitution of the tribunal, as it were. And if A and B both make their nominations, a tribunal comes to be constituted. And I think ONGC, I think Sharan said it exactly right, how it went forward. But it's an interesting point to ask whether, when C says that I am not party to the arbitration agreement, A can file an application for production of documents from C to then show that C is a party to the arbitration agreement. Or shouldn't it be that A already has enough evidence of a mutual intent to bind C to the arbitration agreement? But I think this is one area where perhaps we need to think a little bit more about the judgment, where a party is being made a party to an arbitration agreement without having any say in the constitution of the tribunal. Although, you know, I mean,
yeah.
sorry.
And Kinshuk, just to add some information which is relevant to your question, independent of Cox and Kings, as you know, and as most would, there has been a divergence of views of high courts in India. The Delhi and the Bombay view has been that the tribunal does not have the power to implead. A Gujarat view is that the tribunal does have the power to implead. I don't think that that was really the central focus of Cox and Kings, though it has been addressed. But the fact that it was addressed in part G as opposed to part D, E, and F is perhaps because the lawyers had exhausted themselves by the time they got done with the group companies bit in that judgment. So I think that there's going to be much more on this. And I think that this is really going to be the area of controversy, in my opinion. And I'll add one more thought, that if a non-signatory were to ask me, I mean, the gratuitous advice that I would give here, though some might say that my advice ought to be free at all points because it's never good. But the gratuitous advice that I would give over here is that as against a non-signatory, I would say that if you are being taken to an arbitration without the benefit of participation or opposing an 11, for God's sakes, do not participate in the arbitration, because you may well be able to argue that the award against you is completely non-est. But participating in the arbitration means that you're accepting at least the limited kernel of jurisdiction of the arbitrators to implead you, which may then be giving up a valuable resistance that you otherwise have in an 11 proceeding. So I think the fair reading of the judgment and the act is 11 court prima facie, perhaps even a very de minimis approach, keeping in mind the pro-arbitration or the speed with which arbitration must move forward, and a full-fledged inquiry to be made before the tribunal.
I mean, I have at least 2-3 questions that's emerging from that last answer, but I'm going to resist myself and maybe
Can I
request
just,
you.
sorry, I know you have the right to be asking questions, but I have a very, very good question to Sharon here, is that we have started off this webinar by saying this is a very pro-arbitration judgment, and something which is pro-arbitration, I would in my sense try and say is something which takes the parties away from the court, tries to, you know, make the process much more simpler and get to an award in the quickest possible way. But here, trying to implement it itself, and if you're saying that if this was to be implemented, we will have a prima facie first review by the court and then by a tribunal, I do not know that how can we really call it a very pro-arbitration approach then? Because you're making the parties go to the court first, really, before the tribunal can do it.
Actually, that's what I said, that A, there are two answers. I said that A because paragraph 164 of the judgment categorically says that the referral court has to form a prima facie view of whether the non-signatory is a veritable party to the arbitration agreement. That's actually the language of the judgment. So my answer is not founded on what I think is fair or balanced, but the first part of my answer is founded on a reading of paragraph 164. And it says in both the scenarios, the referral court will be required to so the referral court is clearly the 11 court, will be required to prima facie rule on the existence of the arbitration agreement and whether the non-signatory is a veritable party to the arbitration agreement. So really what I would answer to Neeti is that the judgment itself resonates that point of view. And second is that just because you have a referral court like an 11 court doesn't take away from the pro-arbitration nature of the judgment at all. You have 11s as a process to be followed even as between signatories. We never look at 11 between signatories as being an anti-arbitration measure, because if that was the case, then we really have to amend the act altogether. It's there. It's really where we start our story in arbitration. You go to the 11 court. So I think that just because you have to go through a prima facie filtration before the 11 court doesn't take away from the pro-arbitration nature. But I firmly believe it maintains the balance between binding a non-signatory to an arbitration and someone taking a view of consent. Otherwise, please look at it conversely, that an invoking party without at all being remotely close to the group company's doctrine, no agency, no alter ego, just because somebody connected to a counterparty in an arbitration is perhaps more moneyed, more well-to-do, financial wherewithal. I want him in the arbitration. I'm going to bypass every filtration step. I'm simply going to go to an arbitrator and join him as respondent number 2 in the arbitration. I ask myself at a rudimentary level, is that fair? Is that consent? Is that pro-arbitration? Can you give that kind of power to the arbitrator at stage 1 as against a complete random stranger? So that's the counterpoint. And that's why the 11 courts role is crucial.
Thank you, Sharan. And my apologies. This was a question that was never posed to the Constitution bench, and therefore it'll be unfair to expect an answer. But Stephen, maybe bring you in, and I'm sorry we're actually running out of time, so I'm going to run through some of the questions. Steve, your view from an international perspective: do you see a lot of international tribunals entertain and allow applications for non-joinder?
Yeah, I think this is
for joinder of non-signatories. My apologies.
Yeah, I think this effort to bring non-signatories in is a growing trend, and I think we're seeing that in more and more cases. And I want to put it into two categories. There are some of these concepts get used when government entities are involved, and the question then becomes: is the government itself subject to arbitration where a subsidiary or a ministry has signed something? So there's those set of cases in which some of these concepts are being used. But really quickly, because I know we're running long, in common law jurisdictions, generally, the group of companies doctrine has been, if you put the label group of companies on it, it's been pretty fatal. And we've already talked about this. Sanjeev's talked about the view in Singapore, the view in England, and frankly, it's true in the Second Circuit in the US, it's true in Australia. But what we're seeing in all those jurisdictions, putting aside the civil law jurisdictions where there's more sympathy for this approach already, what we're seeing in all those jurisdictions, I think, is expansive use of concepts like implied consent and estoppel in particular to try to make many of the same arguments. And so I think more and more tribunals are facing arguments based on estoppel, which then look at conduct. And the conduct it looks at isn't very dissimilar to the sorts of conduct and facts that the Supreme Court identified as relevant here, to say that a non-signatory should be party to an arbitration. So I think so the short answer is increasingly happening, and using other labels, but the same sort of reasoning and the same sort of underlying facts to identify conduct that suggests consent. And I think this is a trend, and I guess I'll stop on 2 points. One is I just learned a lot about Section 11, and that had not occurred to me. And I was thinking as I was hearing Sharon to figure out how that would happen in the jurisdictions I practice most often in the UK and in the US. And in the US, you would go to the tribunal for sure. You wouldn't go to you could go to a court first potentially, but you wouldn't ordinarily do that. And what I see in practice is parties starting by either naming a non-signatory as a party from the beginning, or immediately seeking joinder after the arbitration has commenced. And the second point I would make is, again, just to reiterate, parties have this in their control with regard to how they write their arbitration agreements and how they put their contracts together. And I don't want to lose sight of that, because I think that's the practical lesson out of this. If you want to create the efficiencies that the court has led towards supporting through its reasoning, you can do that by the way you contract. And if you want to really protect companies that are in a group from being brought into cases and really reinforce the notion of separate corporate identities and privity of contract, you can be clear about that and how you contract. And I think this is the lesson that we should take away internationally, as well as with Indian parties.
Thanks, Steve. Sanjeev, my next question is for you. And Neeti and Nitin, I may come back to you with a couple of questions. But Sanjeev, before that, are Indian companies, Indian conglomerates, group companies, are they concerned about the judgment? And should they be concerned? Neeti did raise some very valid points. Would like to hear your perspective.
No, I really don't think that there is any cause of a concern, because as has been pointed out earlier in this webinar, is that this is not a change of law, it's a clarification of law. Non-signatories in India into arbitration agreement were being made a part earlier also. And there's a long line of judgment even after pro control, wherein that's a principle which have been upheld. So it's not really in that kind of sense a kind of change of law. It's more clarification of law, and a clarification which is going to bring in more kind of a certainty. I think, in fact, this judgment takes away the fear, let's say, of a multinational which is having multiple company, or an Indian conglomerate, saying that merely because you are a part of a larger group of companies does not mean that you could be involved into the arbitration process, because it sets out quite a lot of other parameters also which are required to be fulfilled. It sets out what is obviously the subject matter of the contract. Were you involved in the negotiation? Were you involved in the performance of the contract? Are the contracts related, interrelated, or not interrelated, etc. So ultimately, it will come out to much more how the contract has been performed, what the role of the parties has been, rather than merely because that they are under the same tree, and ultimately at some level the promoters or the control merges. I think that can be one aspect, but that according to the judgment cannot be the only aspect. So I think for that reason there shouldn't be any kind of a fear around that. It's just kind of lending clarity. And as Steve pointed out, ultimately you must look at how you're drafting the contracts, and that's most crucial and most important. And if, let's say, there are multiple companies which are going to get engaged with a counterparty, it's better to have multiple contracts in case you are not wanting yourselves to be subject to the arbitration. Don't engage in negotiation with a party in contract. Don't engage with performance of a contract. Don't be a party to termination of a contract in case you don't want to be a party to arbitration. So I think they are very clear kind of an indicator which comes out of this particular judgment. And anybody who wants to be out of the ambit of the arbitration and wants to maintain that neutral position as a non-signatory, etc., could follow those rules. But there's nothing to be worried about, because this is, as I said, one of the facts and not the entire kind of a story.
And Sanjeev, just staying with you, given that there's now more clarity, there is more certainty, do you think it's important for parties when they're drafting arbitration clauses in a group of company scenario to pay more attention to what they should do, what they should not do, what they should write, what they should not write? Any practical recommendations that you have, Sanjeev, for users of arbitration?
Absolutely. I think whether the judgment or not the judgment, it's always helpful to be very clear in the contracts. I think one should. Unfortunately, in India, the arbitration clauses, as they call, are the midnight clauses. And generally, whenever a matter goes into disputes, I start looking at the contract from the end of it, not from the start of it, because I know that's where I'm going to find the arbitration clause. It's somewhere towards the end, if not the last clause. So I think the kind of clarity is always important. But what is important in this particular judgment is that obviously you are getting dragged, like if I can use that word, into an arbitration despite being a non-signatory. It's your intent which is being inferred from your conduct, not really from the terms of the contract. Because if you look at the terms of the contract and you have not signed it, the intent is clear that you really didn't want it to be a party of this particular arbitration agreement. But you are getting dragged into it because obviously your conduct. Did you perform the contract? Did you participate in the negotiation? Is it a contract which is a composite contract to a similar kind of a transaction which you have entered into others, etc. also? Therefore, I think one should be wary of the conduct also. And let's say you are a part of a larger group and you have to render services to a counterparty because your sister concern is rendering services. I think it would be more appropriate that you enter into a supplementary kind of a contract and not provide those services at the back of the same contract which has already been entered into. So whenever you are wanting to have a relationship which is different and distinct from, let's say, a larger contract or an umbrella contract, please enter into a separate kind of a contract with a separate dispute resolution clause. And I think that would the concerns that somebody would unnecessarily get dragged into this will go away in case these kind of things are adopted.
Thank you, Sanjeev. We are running out of time. I'm going to take one question from the audience before we close. Ritin, any issues that you believe remain unaddressed? I know we dealt with a couple of them. Anything that you believe remain unaddressed? And also, I invite final comments from you, Neeti, Sharan, Steve, on very briefly on any recommendation, any thoughts on what users of arbitration should keep in mind post this judgment. Maybe Ritin, you can go first, and then we'll sum up with Neeti, Sharan, and Steve very, very briefly.
Yeah. No, look, I don't think anything can be really said to be left unaddressed. But that doesn't mean this is the final word on how non-signatories can be impleaded as parties to the arbitration agreement. I mean, I think the court has said also that they don't wish to adopt a dogmatic approach or to tie a tribunal's hands or referral court's hands, as Sharan says, to make a prima facie determination. So nothing's unaddressed, but of course, it will be a fact-specific determination. And I think just in terms of responding to something Sanjeev was also just saying, and Stephen as well, how do you write your contract to protect yourself? One is, of course, what Sanjeev says, that if in the performance you want to make it clear that you have a separate and distinct set of obligations, please enter into a separate agreement. The second thing is that when it comes to negotiation, and I think some of us argued this in the court, that negotiation is really by individuals, not by other corporate entities. But I wonder whether the answer is in writing in the arbitration clause that it doesn't bind other parties. If that's what you intend to write, is it as simple as that? Because actually it is as simple as that in how you wrote your arbitration agreement, that the parties to this agreement will refer disputes between them to arbitration. But maybe if you really do want to stop other parties from being arrayed despite being non-signatories, maybe that's how you express your intent. But just last point, that you can do at the point of formation of the contract. The court's gone a little further and said, even after formation, if you participate in performance or termination. So I'm not sure how you can protect yourself against a subsequent tribunal or court finding that you performed this agreement. And just to leave one thought, which I think was a very interesting concurring judgment by Justice Narasimha, where he relies on 7.4b. Because I had always thought that the various limbs of 7.4 are distinct and separate. That if you have an arbitration agreement contained in a document signed by the parties, you simply don't go to 7.4b. And equally, if you have something in 7.4b, you don't go to 7.4c. But I thought the concurring judgment was actually adding that whole aspect to the debate, and I found it very interesting for that reason.
Yeah.
Thanks.
Neeti, Sharan, Steve, any closing thoughts? Very, very briefly. I'm really sorry we're running out of time, but very briefly, maybe in 30 seconds, if that's possible.
Right. So, Kinshuk, I'll just end up by saying that NCI is now revising its rule after 7 years of its existence. Joinder was always one of the very sticky points for us, even when we started off with NCIA. And I can tell you it has been very hotly debated now that we are drafting our rules and we have almost a draft ready. And very soon, probably all of you, at least in the webinar here with me as a panelist, would be receiving a copy and would love to have your comments on how we are drafting it. We're definitely adding now a provision on joinder of non-signatories. And Sharan, maybe we can take the discussion offline, have a few things to discuss with you on what we said. But maybe rather than going to a section 11, if parties do opt for institutional arbitration, they could have the advantage of institution deciding and then the tribunal going to it. I'll conclude with that. Maybe institutional arbitration could help you, even with the joinder of non-signatories.
And Sharan, you don't need to respond to that online. You can respond to that offline. Any closing thoughts in 30 seconds?
Yeah, in 30 seconds, when Neeti says that we can take this offline, it's like when you leave the bar and someone says, I'm waiting for you outside. It's not a good sign. Anyway, so
He's in Delhi,
that,
you're in
that
Bombay.
part, very, very quickly, one closing thought is that when the Bhatia International judgment was rendered by the Supreme Court, which came in for a fair amount of criticism, it said that if you've not excluded Section 9, then it may apply even to a foreign seated arbitration. History tells us that we then had a slew of arbitration agreements in India where you expressly excluded Section 9. I was thinking back to that time in response to what Ritin and what Stephen said, which is that is there room for reducing the applicability of these various theories of implied consent by express language? But and I'm not answering this question, the circular nature of that argument is that the whole basis of this judgment is that what you don't say on paper sometimes matters more than what you say on paper. We have to look at commercial modern reality. And if you look at it in that sense, it's really the classic circular argument, which one really will prevail. And I think that it's going to happen, but I'm not sure that the courts will say that because you've said that group companies doctrine will not apply to this arbitration agreement, it means that it will not apply, because it's really like saying that the law will not apply to me. Can you say that? I'm only putting it out there as a thought. Yeah. And I really admire Stephen knowing so many jurisdictions and familiarity with law in so many places. We're struggling with just one jurisdiction and one set of laws, you know.
No, absolutely. I know for a fact that Steve has been observing developments for several years. And so,
really.
Steve, you have the benefit of the last comment.
Well, I'm going to pick up on what Sharon said, which is I don't think you can simply contract out of all the implications of the court's approach, because it focuses on conduct, including post-agreement conduct. And I think those are the open questions. We see this across jurisdictions, speaking of multiple jurisdictions. In some jurisdictions, the notion is you need to show consent at the time the arbitration agreement is made. The court repeatedly talks about mutual intent, but then doesn't talk much about the other side's conduct. I think there's a whole host of open questions that we need to explore, and we'll see being explored about what does mutual intent mean? What can you do afterwards? And so I guess I leave it with, in some ways, it's an invitation to remind people that maybe you do want to have everybody who you can control in the same proceeding. Do that clearly if you want to. The question of whether subsequent conduct may get you into an agreement you probably can't completely contract for, but the more you're aware of it, the more you may be able to moderate your conduct to have better control and certainty about what risks you're taking.
Thank you so much, everybody, and for taking out time, of course, and participating in the webinar with such enthusiasm. I think we have enough open questions to organize another webinar soon. And thank you, of course, to all those who registered and attended the webinar. I hope you found the webinar informative. We will be sending you a brief summary of today's discussion, at least I'll attempt to do that, along with a link to the webinar. You will separately receive a request for a feedback on the webinar. Please take some time out. Give us your feedback, because that encourages us to organize more webinars of this kind. Thank you all. Thank you for joining us.
And thanks, Kinshuk, for the very insightful questions. Thank you.
Thank you all.
Thank you.
Thank you, everyone. Thank you.
Thank you. Bye.